All right. Well, thank you so much for joining us here at Fraud in America. Today, we have a special guest with us, United States Attorney for the District of Rhode Island, Zachary Cunha. Thank you for joining us.
Thank you so much for having me. It's great to be with you.
Well, thanks again. I wanted to start with maybe just you could give us a little bit of your background, kind of why you decided to get into public service and kind of what you've been doing up until this point.
Well, I'll try not to bore your readers to tears. I'll give you a little bit of an overview. I've been lucky enough to be in public service for the entirety of my career. I started as a lawyer with the city of New York more than 20 years ago on September 10th, 2001. Next day was a little bit eventful. And then I joined the Justice Department almost 20 years ago in 2005. And I've had the privilege over the course of my career before coming into this role of serving in 3 different U.S. attorney's offices in Brooklyn in the Eastern District of New York, in Boston in the District of Massachusetts, and then I joined this office about a decade ago. And, in terms of where the impetus to public service comes from, I think, we all have our own story. I'm the first lawyer in my family. Both of my grandfathers were factory workers. One of them was a Portuguese immigrant who came here when he was 9 years old and never went beyond 6th grade in school and built a small business as a craftsman and prospered in this country. And sort of the 2 takeaways, he was one of the great influences in my life, and sort of the 2 messages that were always imparted in my family were, 1, this country affords people amazing opportunities, and with that comes an obligation to give back. And 2, one of the things that he was always richly appreciative of was the fact that government in America stands up for people having those opportunities. And one of the things that's sort of been a through line in my career, particularly in the kind of work that we're talking about today, is making sure that folks get a fair shake, that our markets are fair, that our government gets what it pays for. And that's a core part of what we do. And one of the things that keeps me engaged and energized in the work that I do in this job, which I was privileged in 2021 to get appointed as the United States Attorney in this district. And that's the work I'm doing today.
That's so interesting. I came from a kind of similar background. I'm the first person in my family to graduate from college also. And I also had kind of a working class background. And I think that's also what kind of drove me into this work as well. And I think that really kind of, you can see that coming through in a lot of people that do this kind of work. You can see that really drives them to do the right thing to get it for people to really get a fair shake. And I can really appreciate that. I want to go back a little bit though. You got to tell me what it's like coming into your first job and the next day is 9/11.
That was a hard day. And as it happened, my job was working for the city of New York, and our offices were 2 doors down from the Trade Center. And I was commuting in on the bus from my apartment way out in Brooklyn. And I remember getting off the bus and walking up Greenwich Street towards Church Street and seeing what looked like a ticker tape parade. There were little bits of paper drifting down in the atmosphere. And as I got a little bit closer to Liberty Plaza, I was standing there with hundreds of other people who were staring up. At that point, the North Tower had been hit by the first of the 2 planes. And there was literally this huge, gaping, flaming rent in the side of the tower. And what had looked like ticker tape were actually pieces of paper that were sort of fluttering down. And so, eventually, I won't bore you with the entirety of the story, but my incoming class at the New York City Law Department was supposed to have our picture taken with the mayor that morning. And I guess in a crisis, you focus on what it is you're supposed to be doing. In my head, I'm thinking, boy, I'm going to be late for my appointment, notwithstanding everything else that was going on. And I made my way to the office where everyone was gathered. We were evacuated shortly after that. And it was just a surreal day walking uptown as the events unfolded, and eventually the towers collapsed. And it was really a truly surreal experience. And given that I was working for the city, it was a surreal and fascinating way to start my career as a lawyer.
And did that impact kind of your job at that point? Did, or did that not really have anything to do with what you were doing, kind of?
Well, on a practical level, we were out of our space for about 9 months because that was obviously a frozen zone. I was involved in some litigation later on relative to the city police department's ability to do intelligence gathering in the wake of 9/11. And so it affected my job in that sense. But most of the litigation I was doing was um, federal court litigation of all different stripes. So there was some overlap, but it really had more of a understandably personal effect than a professional.
Yeah, absolutely. I can see that. Okay, well, let's move into, okay, you've made it now here to the District of Rhode Island. Can you tell me a little bit more about your office, kind of what your personnel looks like, and just the kinds of things that your office is working on?
I'm happy to. I mean, one of the interesting things for me coming from two other U.S. attorney's offices, both of which are considered extra large, is this is a different environment. We have 25 attorneys, 20 of them in our criminal division, and 5 of them doing civil litigation, both affirmative and defensive. And, the nature of that is people very often are more generalists than they might be in some of the other offices where people tend to specialize. But the other aspect of it is because we're a small district and a geographically compact state, we have a lot of opportunities to work both with our state counterparts, our state and local and federal law enforcement counterparts, and really, sort of work innovatively to deal with the specific crime issues that we have in Rhode Island, but also to focus to the extent that we have the capacity, and I'm working very hard to build that capacity on what I'll call larger, more nationally impactful cases. One of the principles that I operate by is that some of these big cases, particularly False Claims Act cases, large white-collar cases that affect industries and industry behavior, can be done just as well and just as effectively in the small office as they can in some of the larger metropolitan offices. And I try to bring a lot of the things that I have worked on over the years, whether it's in Boston or in Brooklyn, to our practice here. And I think we're making good headway in terms of building that capacity.
So talk about some of obviously the size of the offices are different, but talk about some of the kind of, are you shell shocked by coming from an extra large office into a small office, and how are you building that infrastructure there?
No, shell shock's the wrong word. I'm delighted. This is an absolutely wonderful office, and it's a privilege to lead it. And one of the things I like about the size of our office is we have that flexibility. And we're not beholden to a particular industry or a particular issue because of where we are located geographically, and we have to deal with an overwhelming influx of a particular type of case. We have that flexibility. So in terms of how are we building out that capacity, we have some wonderful staff already, and I've worked very hard to bring on board attorneys who have that complex white collar set of skills, whether it's civil or criminal, to do these cases. We're blessed in this district that we have great working relationships. I think a lot of people, who look at these cases think that the government either does these investigations in a vacuum, or if someone is doing the work, it's the FBI. And the FBI does wonderful work, but we have many other agency partners. When we talk about the False Claims Act, a lot of what we're talking about is healthcare fraud or defense procurement fraud. And given our geographic compactness, we're blessed to really have terrific agents, whether it's the offices of Inspector General for Health and Human Services or the Department of Defense. Some of those folks we've actually convinced to co-locate in our space here in the U.S. Attorney's Office so that we can work these cases more effectively and more efficiently. And it's proven to be a tremendous force multiplier when it comes to building out these cases.
Yeah, let's talk. I want to go back and talk about some of your big, huge wins that you've had in some of your other offices. But I do want to talk. You've had some recent kind of big wins in your office that really involved. I think it was something like 9 different key TAM actions brought under the False Claims Act, involving a bunch of different offices, a bunch of different agencies against Kindred. It was a hospice case. Can you talk a little bit about that case and how you kind of dealt with all these different agencies and offices working together, and a bunch of different kind of whistleblower cases coming together.
Well, that's a great example because it kind of exemplifies, philosophically how we approach these cases. Big cases are great. Big cases get headlines. Big cases make impact on industry. But every case is important. And one of the most important things, and I hope we'll have the chance to talk about this a little bit more, is the relationship that we develop with whistleblowers and the relationships that we develop with their counsel. And part of managing that relationship is also managing the interplay with our federal agent counterparts, with our DOJ counterparts in Washington, with agency regulatory counterparts. And the Kindred case is a great example of key TAMs being filed in multiple districts. You have potentially overlapping claims that implicate different programs. And, one of the roles that we see ourselves having is not to push to the front of the pack and make sure that we're the ones doing this case, but what can we add to make sure that the case gets done effectively and efficiently? And so ultimately, although I won't go too far into specifics, we had a relator here in Rhode Island who ultimately their recovery was not an overwhelmingly large recovery, but they were helpful in and allowed us to play an instrumental role in working with all of these different constituencies and our U.S. attorney colleagues around the country to get the case done. And it also exemplified to me, when I talk about the size of the recovery wasn't necessarily huge relative to an individual relator. One of the things that has always struck me in doing this work for so many years is what motivates whistleblowers to come forward and do the work that they do. And I think a lot of people who are on the outside of this process tend to think, well, obviously it's the money. There's a big recovery at the end of the day. And in my experience, I don't think that's the case at all. I mean, first, logistically, yeah, and it's possible that in some cases there is a very large recovery, but often that's very much uncertain and it's many years away. And there's a great deal that can happen in the interim. And in the meantime, you have folks who are putting their job, their career, in some cases their family stability at risk to come forward and blow the whistle on what they're seeing. And, I would say 9 times out of 10, in this case is an example, and there are many others that I've encountered across the course of my career, what's really motivating people is the desire to do the right thing. And they see something that is wrong and they want to step up and they want to deal with it. And often the people who are doing the wrong are folks who are credentialed and powerful and in a position to impact their livelihood and potentially blackball them in an industry. And they do it anyway because it's the right thing to do. And part of our job is to step up and support them in that effort. Forgive me for getting on my soapbox.
No, anytime, get on your soapbox anytime. It is so heartening to hear you say that. Honestly, I feel like not every, everyone working in government, not everyone does understand that there is so much risk in coming forward as a whistleblower, and that mostly it is doing the right thing that is motivating these whistleblowers. And in this case, for instance, what you just said is, in a hospice case, it's not, just the money or whatever. It's, if someone's getting hospice care, they're not getting the treatment that they need. So there's real patient harm at play here. And so, there's real motivation to help patients that are making these whistleblowers come forward.
That is so true. I mean, if I can give you a couple of other examples, we had a case. I was actually lucky enough to work on this case before I was appointed as U.S. attorney, but we had a case involving a company, a small business, a family business in Rhode Island that manufactured uniforms for the military. They were very specialized uniforms. They were supposed to be invisible to infrared night vision goggles. And you had again, going back to your story and mine, a first generation businessman who has worked very hard to build this business. And he sees online a competitor selling what looks like his product for a third of the cost and realizes that what's going on here is someone's having a foreign made knockoff. And so that affects his business. It affects, as we investigated, it turned out that the foreign made knockoff wasn't just less expensive, it was also lit up like a Christmas tree on infrared goggles when you have soldiers out on the front line abroad. that has a real tremendous impact on people's lives. And we did that case criminally and civilly. And that's, yet another example of the kind of work that matters. Recently, we did a case involving, no one outside Rhode Island will get the immediate reference, but we have the interchange of two highways, routes 6 and 10, and a company was contracted to build an overpass. And that money partially came from the federal government. And one of the things that the company promised to do was to use clean fill when it built the overpass. This overpass abuts an underprivileged neighborhood. And instead, what the company did was take contaminated fill from another work site up in Massachusetts and dump it at this location. And, once again, what's motivating people here is not a lot of money. It's the fact that somebody is cutting corners, overbilling the federal government, and at the same time doing something that they're not supposed to do, maybe because they think the community next door isn't going to have the heft to stop them from doing it. Well, we do, and we can, but we can't do it alone because oftentimes we don't get information about these kinds of conduct, this kind of conduct or misconduct, without whistleblowers being brave enough to come forward.
And so you sound like someone who does appreciate and understand that the whistleblowers are the ones with this information and do want to come forward. How has your relationship been in the past, in this office and in your past offices, working with whistleblowers and their counsel on these cases? Have you worked pretty kind of hand in hand with them on cases? Or I'm sure it depends, but have you had a good relationship for the most part working with whistleblowers and their counsel?
I think I've been lucky enough that I have. One of the things that's great that I love about the False Claims Act is how iterative it is and how it has grown over the years to reach new practice areas and new issues. And, I think obviously the relationship is always easiest with folks who are intimately familiar with how the FCA works and how the process works. But I'm hard pressed to think of a situation where we've really had, irreconcilable differences in terms of how we proceed with the case. I mean, again, to pull back the curtain a little bit and give you a sense of how some of these cases work out, they're not just the impetus for fiscal recovery to the federal government. What comes in as a False Claims Act case is often a great lead for us to open a criminal investigation. That was the case in the two instances that I just mentioned to you. And so sometimes, on top of the fact that the whistleblower is putting themselves at risk, they may play a role in our investigation. And you don't get to that point without developing a considerable measure of trust. And part of that trust is making them understand that, we have different roles. We have an institutional role, and there may come a point when their identity and their information needs to be publicly disclosed. For some people, that's not an issue. For others, it is. But for those that it is, we're going to try as best we can to protect them and make it clear to opposing counsel that, although some of the whistleblower protection issues fall on their own attorneys, that we have every expectation that they are not going to retaliate, that they're not going to take adverse action against someone who has spoken up and has stood up. And we try as best we can to take care of the whistleblowers who have stepped up and are partnering with us to do this work.
And now let's talk about kind of other kinds of cases that you're seeing in your office right now. I know you are seeing a lot of healthcare cases, and we talked a little bit about the infrastructure cases that you're seeing in your office as well. Are you seeing a lot of, as far as False Claims Act cases, are you seeing still, I know a lot of offices are seeing a lot of PPP cases coming up now, some other kinds of like cybersecurity cases and stuff like that. Is that stuff that you're seeing in your office?
We're seeing the gamut. I mean, as I mentioned, the FCA has obviously been around a long time, since the guy over my shoulder signed it into law in the middle of the Civil War. And then it had its renaissance with defense procurement in the 80s and the 90s. And when I came into the department in the early 2000s was sort of when healthcare was really exploding as an FCA frontier. And all of those things are still there. It's just a question that increasingly you're seeing either new variations on old schemes, or you're seeing new areas where both, the federal government is involved and there's billing, PPP fraud being a good example, or whistleblowers are being more savvy about the availability of an FCA remedy and are bringing the claim. And I think the government is also becoming more savvy about how effective this is as a mechanism to get people to disclose wrongdoing. I mean, the FCA has obviously been around for a long time, but over the past decade or so, you've seen the SEC get more active with their whistleblower provisions, the Consumer Financial Protection Bureau, and within the past month, the department, the criminal division down in Washington, has rolled out a pilot program using asset forfeiture funds to try and once again replicate this model and maybe reach some areas where the FCA hasn't reached traditionally, because you're talking about private payer healthcare, or you're talking about financially regulated areas where there aren't government payments in the same sense that traditionally underlie False Claims Act cases. So when I talk about, you mentioned the Kindred case, when I talk about relations amongst U.S. attorneys' offices or with agencies, part of that is also playing a role with some of these newer players in the whistleblower space. And how can we effectively help and bring our experience to bear and figure out, who's got the best tool to bring this claim, and what have we learned from dealing with this kind of issue in the past that might be of help to you. At the end of the day, maybe the SEC has a better avenue with respect to this than we do, or vice versa. And we try and assist whistleblowers to the extent we can in navigating some of that stuff behind the scenes.
And I think your office is actually really good at that. I think you have a good sense of, helping figure out where maybe the claim might go that's the best place for it. Have you had, I know this just wasn't, the pilot program was just announced, but do you have thoughts on maybe, and maybe you can't speak to this yet, but kind of I don't know, any thoughts on the new program and kind of where it might go, and also kind of the interactions between the different agency programs and the False Claims Act and how those kind of things interact?
So that's a great question. I think that, one of the reasons that our office has been successful, and we're certainly not the only ones in this space that have been, there are a lot of other U.S. attorneys' offices that have a well-earned reputation for doing effective work in the False Claims Act space, is, a willingness to reach out, whether it's to an agency about their whistleblower program, to another U.S. attorney's office about who ought to take the lead on a particular investigation, or to a component at Main Justice and say, hey, we've seen this kind of issue in our False Claims Act practice before. Because I think one of the great things about the False Claims Act is the U.S. attorney's offices around the country have been traditionally a bit of a leader when it comes to FCA litigation, in partnership with our colleagues at the Civil Fraud Section down at Main Justice. And one of the roles that we can play, and one of the reasons we can play that effectively, is to be an honest broker, and reach out and suggest, who you ought to reach out to with a particular claim, whether you ought to potentially loop in another office or another component. And although there are limits on some of the advice that we can give, we can perhaps kind of steer you to who is the best initial point of contact for your lawyer to reach out to with a particular type of claim.
And that's just so really useful for everybody. Any potential whistleblower out there listening, don't be afraid to reach out to someone in the government. They are not afraid to help you out. It's in their best interest as well to get you to the right place. So let's go back really quickly to way back to 2009, because I really want to talk about you. You were part of, maybe solely responsible for, if I must say, the $2.3 billion settlement in that Pfizer case. That was the biggest at the time, maybe still, healthcare fraud settlement that the DOJ was ever involved in. Can you talk about that Pfizer settlement a little bit and all of the kind of moving parts that were involved in that?
Well, first, this is, I think, the first time in our discussion that I strenuously disagree with you, because I certainly was not single-handedly responsible for that case.
I was kind of kidding, but,
I I was privileged to be part of a great team of attorneys that did that work. And it kind of exemplifies the team approach, because ultimately that investigation involved a criminal component with respect to one particular drug, a painkiller, and then multiple FCA lawsuits that had been filed with respect to different drugs that the company was marketing. One of the particular areas of focus that I was working on was with respect to an antibiotic called Zyvox, which what made that particular claim significant was the notion that this was an antibiotic of last resort to be used for methicillin-resistant Staph aureus, or, in common parlance, flesh-eating bacteria that you do not want anywhere in your body in a hospital infection setting. And the notion is not just that there was marketing conduct that was problematic, but the potential long-term effects of that were depriving people who desperately need something that can help them when no other antibiotic will do the trick. So, it was a confluence of all of the things that we see in some of our best FCA cases, where there is conduct that significantly affects the federal government in a fiscal sense, but also tremendously impacts people's lives in a day-to-day and actual sense. So I worked on that case alongside several colleagues in the District of Massachusetts, as well as the U.S. Attorney's offices in Philadelphia, attorneys at Maine Justice. And after a couple of years, several years of very significant work, we managed to reach both a civil and criminal resolution in that case. And I'm proud of that resolution, but I'm proud of that as part of, a number of these cases that we've done over the years in the pharmaceutical industry and elsewhere, because at the end of the day, the recovery matters, but what also matters is we are often successful, and we hope we're successful at changing behavior in an industry. Whether I look back to that era and I think about some of the things that were done in terms of kickbacks to promote doctors prescribing drugs for uses that they were not approved, whether it was sporting events or dinners or all kinds of overt financial incentives, or the incentive compensation of sales reps, which at least at some companies is no longer the case as a result of some of the False Claims Act and other enforcement work that has been done by the government. And it's refreshing to see the work that you do hopefully make a difference in keeping industries honest. And that was an eye-opening experience for me, just as some of the early affirmative work that I did for the government just reinforced for me how powerful this is as a tool and how much of a difference we can make. And we couldn't have done that without the multiple relators who came forward in that case.
Yeah, I think that the deterrent effect of these cases isn't talked about enough, and it's not really quantifiable. But when you think about it, behaviors really did change after those big pharmaceutical cases. And I think they're continuing to change, as we continue to chase down these different frauds. We really are changing behavior in these industries. And it's nice to make a difference in this area.
It's nice to make a difference. Regrettably, fraud and ingenuity spring eternal. And that's why we're here. And that's why we expand the reach of the False Claims Act. And we hopefully get the message out to folks that there's honorable work to be done in blowing the whistle and addressing fraud in whatever form it's taking right now.
Absolutely. So on that note, what's on the horizon for the District of Rhode Island and yourself?
Well, we have a couple things that are in the pipeline that I hope will see public visibility in the next few months. In all of the spaces that we've talked about, we're going to continue to build our capacity personnel-wise. We're going to continue, I hope, for a small state up here in New England to punch above our weight, and we're going to continue doing the work.
All right, that sounds great. Well, thank you again for joining us today, U.S. Attorney Cunha. We're looking forward to seeing what you're going to do up there in Rhode Island, and thank you for joining us here on Fraud in America. Thank you for Getnik Law for sponsoring us today, and thanks again for joining us.
It's been my absolute pleasure. Take care.
Thanks. Thank you.
Our 2024 sponsor is Getnik Law, a boutique Manhattan law firm dedicated to fighting fraud and promoting business integrity. Learn more about the firm at www.getniklaw.com. If you believe you've witnessed fraud against the government or on the financial markets, or want to learn more about the laws that exist to fight fraud, visit TAF.org, where you can find a directory of whistleblower attorneys who work across the country. On our website, you can find information about the nation's whistleblower laws and programs, and a way to donate to our organization as we continue to fight attacks on whistleblowers and these laws. Fraud in America is presented by the Anti-Fraud Coalition. Jacqueline DeMar is our host. James King is our executive producer. The website for Fraud in America was designed by Wide Eye Creative. Our artwork is by PPA Agency. And our theme song is by Spatial Relations.